We'll now recognize Representative Bradley Byrne for the purposes of an opening statement. We look forward to hearing from you, Congressman Byrne, on your experience to let us know what's happening in the private sector and your time that you spent working on those cases. So the Chair now recognizes you for 5 minutes.
Thank you, Chairman Harper, and Ranking Member Brady, members of the committee. I appreciate the opportunity to testify before the Chair on this important topic. Title VII of the Civil Rights Act of 1964 prohibits discrimination on the basis of race, color, religion, sex, or national origin. In 1986, sexual harassment was recognized by the Supreme Court as a violation of Title VII. In 1995, Congress passed the Congressional Accountability Act, or CAA, subjecting us to Title VII. Based on my prior experience and recent research into the current policies regarding harassment here in Congress, I want to make a few observations and offer some of my own suggestions. First, we need to mandate harassment training. I strongly believe the House should require mandatory sexual harassment training for all members and employees. Recent events have demonstrated that training, while available to members of Congress and employees, is underutilized. I will also note that mandatory training in the House is not unprecedented and is already required for ethics and computer security. There are also multiple harassment trainings currently provided by different congressional support offices. It's my opinion that this committee should settle on one high-quality training product to make sure that all House employees are trained in the same manner. Number two, we should consider a universal harassment policy for all House employees. Although not required by law, creating and enforcing anti-harassment policies is now a near universal norm in the private sector. As you are aware, each individual congressional office is an independent hiring authority, and each office has its own policies. Given the unique nature of House employment, it is my opinion that a uniform, universal anti-harassment policy based upon the CAA and applicable to all House members and employees would be much more effective in curbing unwanted sexual harassment than the current patchwork of different harassment policies that we have today throughout offices on Capitol Hill. With a universal policy, the training of House employees would be simplified and made consistent across the House. Number three, we should examine the Congressional Accountability Act and consider improvements to the complaint and enforcement process. It's been over 20 years since Congress enacted the Congressional Accountability Act. I believe this is an opportune time to revisit and consider revisions to this important statute. The statutory provisions governing harassment claims in the legislative branch are different than those that govern private sector employment and other public employees. In the private sector, the EEOC administers and enforces laws against workforce discrimination. The EEOC investigates discrimination complaints based upon a protected class. The process begins by an aggrieved party filing a charge with the EEOC. The EEOC then has the option to request the parties engage in mediation. However, mediation is not required for either party. If mediation is not requested or it's unsuccessful, the EEOC has investigatory power, including subpoena power. After the investigatory process is complete, the EEOC has the right to bring a case upon an aggrieved individual's behalf or to issue the individual a right to sue letter, allowing the aggrieved party to bring litigation. In contrast, the Office of Compliance has no investigative authority and cannot prosecute harassment claims. And the CAA requires mandatory counseling, as Ms. Spear pointed out, for those making claims. We should work to bring the OOC process and authority in line with that of the Equal Employment Opportunity Commission. Other suggestions for revisions to the Act, in my opinion, would include subjecting our unpaid workforce, such as interns, pages, and fellows, to the Act's anti-discrimination provisions. Certainly, these changes will increase the workload of the OOC, and we need to be prepared to provide them the necessary appropriations. Fourth, we need to increase member accountability. Given the constitutional nature of our offices, member-on-member sexual harassment is not something where harassment law and the employment structure can easily be applied. In this matter, it is my opinion that we must exercise our constitutional duty to discipline our own membership. I believe we should adopt a specific policy for this kind of behavior in our Code of Official Conduct, more expressly than one we presently have. that would send a signal that member-on-member sexual harassment will not be tolerated and that members of this body support those being harassed and reporting these incidents to the Ethics Committee. Moreover, while an employee may be able to obtain monetary relief under the CAA, a settlement or judgment is paid by the taxpayers. Personally, I find this unacceptable. If a member of Congress settles a claim as the harasser or is found liable as the harasser, it is my belief that the member should be personally liable or required to repay the Treasury for such damages. Furthermore, any payment out of the Treasury in response to a claim of discrimination or harassment by House office should be made in a manner that is fully transparent. Finally, it is my opinion that given the inherent power differential between a member and their staff that they supervise, we should include a strict prohibition on members engaging in a sexual relationship with staff under their direct supervision. In closing, I appreciate the opportunity to share my observations and would be happy to provide more information to the committee as necessary.